So the Constitution says we have a judiciary. It's going to be a robust judiciary, and the apex court in Kenya is going to be the Supreme Court. And it even says how many judges sit in the Supreme Court, and says the leadership of the Supreme Court. It's the president of the Supreme Court shall be the Chief Justice of the Republic of Kenya, who is the head of the judiciary, who also heads very many things, the chair of the Judicial Service Commission, the chair of the National Council on Administration of Justice, the chair of very many things. The current Chief Justice is Her Ladyship Martha Koome, and she's our guest. Good morning, Chief Justice.
Good morning, Latiff.
Welcome back to the hot seat of the Situation Room.
Thank you for having me.
It's been a while. We cooled it down for you.
I don't know whether you cooled it down or you heated it for me.
Karibu sana.
Asante
It's good to see you. And as we're going to talk about the Supreme Court and the 12 years of the Supreme Court, what it has achieved, is it defending the Constitution, what's it meant to do, and is it doing exactly that? But first, CT will welcome you with the day's proverb. This week, he's in countries south of the Sahara.
Yes,
I
am.
Yeah.
And the specific country that we are mining proverbs from is the Democratic Republic of
Congo.
Yes, I was going to say du Congo because that is the French way of looking at it. DRC. Yes, a very populous country, 109 million people.
Wow.
And counting.
As at the last count.
Yes. They have lost very many of their citizens due to wars. The last one cost them 5.4 million people died. That's how terrible wars can be. The proverb: a message from a dead man is poison for the one who doesn't respect it. A message from a dead man is poison for the one who doesn't respect it.
Madam CJ, what do you think this proverb is saying?
It sounds like a curse.
You think so?
Yes, it does. Yes, it does. But
So what's the lesson here? A message from a dead man.
is poison,
Poison.
to one who doesn't respect it.
Yeah.
Yes, this, which means we must always respect what the dead have said. Otherwise, it becomes a curse. But that's a tough country.
Yes, it is. Yes, it is. Yes, it is. You see, if we talk about, for instance, the constitution we currently have, in 30 years from now, we'll still have this constitution. It may have been changed. The people who are behind that constitution will be dead. Now, those dead people spoke to that constitution and they ushered it in. And for a very good reason. To understand it better, just look at the Americans who just had an election. And they have a constitution we keep talking about. The people who crafted it and started that constitution are all dead. But the constitution
Is alive.
It's alive.
precisely is a living
And
document.
speaking.
And it's
And
speaking.
speaking. Now, if you ignore what it is telling you, bas.
Krisha.
And that's where you're right. It becomes like a
A
curse.
curse.
CJ, the Constitution of Kenya establishes the Supreme Court of Kenya, right? What is the job that the Supreme Court is given by the Constitution?
It is clearly set out in the Constitution. The Supreme Court is the apex court in the sense that it determines certain matters that are defined in the Constitution to their logical conclusion, brings them to a logical conclusion. The presidential election dispute, appeals that involve the interpretation and application of the Constitution, matters that have been certified as raising general public interests, and issues to do with devolution, especially advisory opinions that are brought to the Supreme Court. So those are the jurisdictions that are given by the Constitution to the Supreme Court, including, of course, an appeal arising out of a decision of a tribunal to remove a judge. And one jurisdiction we have never exercised to determine whether there is a state of emergency, a declaration of state of emergency.
Okay.
Yes.
Now, if we look at all those, would you say that in the last 12 years, the public has understood the job of the Supreme Court of Kenya?
That's work in progress because the population is transient in the sense that the people who made the Constitution, many of them maybe have transitioned. We have young people who are children when the Constitution was promulgated about 14 years ago. Those who are teenagers now are adults. We have others who are not born, but they are born. They are 14 years. So it's a continuous process of engagement to let Kenyans know what the Constitution says, the institutions that have been created by the Constitution to serve the people, the institutions that have been given power, the sovereign power of the people to serve the people. So it's a continuous engagement, and that is why we felt it was necessary for the Supreme Court to celebrate 12 years so that we can introspect and we can reflect together with Kenyans to see what it is that the Supreme Court has done in the last 12 years, shaping jurisprudence, determining complex issues that bring stability in the law, in the economic setup, in the land issues, in the human rights, in the political landscape. So we have had that conversation involving stakeholders, scholars, lawyers, experts, other jurists, judges, chief justices from other jurisdictions. We had 6 chief justices attend the conference, and I think one of them, the Chief Justice of Liberia, was your honored guest.
Yep.
So it was a very deep conversation to let Kenyans know what the Supreme Court does, because sometimes we are mistaken that we are only seen after 5 years to determine the presidential election dispute. We disappear to nowhere, and then we appear again after 5 years. That's not the case. We are busy throughout the year.
You know, the journey to the 2010 Constitution had very many aspects into it. One of the strongest ones was the fact that the Independence Constitution had been amended so many times. In fact, people had said it had been mutilated. And there are those that say that by establishing the Supreme Court and giving it specifically that mandate to interpret the Constitution, this was the body that was given the job of defending the Constitution, not just the letter of the Constitution, but also the spirit of the Constitution. Has it done that?
We have done that superbly, even according to the verdict of the stakeholders who attended the conference, and they examined deeply the jurisprudence that has been churned by the Supreme Court. The leading case in constitutional reform or amendments is the Building Bridges case, which is still fresh in our minds. You remember there was an attempt, probably by the political class, to amend the Constitution through major amendments of almost over 70 articles were being affected by that move to actually overhaul the Constitution. And you remember the Supreme Court handled that matter, and with the finality brought to an end that attempt to mutilate the Constitution, and even to bring other ways of amending the Constitution which had been proposed, which was being borrowed from other jurisdictions. We were able to examine our Constitution and saw that it has an inbuilt system of amendment and we did not have to bring other theories from other countries to see how to amend our constitution. It is self-sufficient. If you want to amend it, you just turn into Article 255, 256, and 257. And perhaps what we recommended was that Parliament should enact a law that guides amendment of the Constitution. Much the same way we are in the CKERC when we were amending this Constitution, and we developed even rules and regulations that guided every other step so that there are no missteps in between, and Kenyans are aware what steps to take if they want to amend the Constitution.
Madam CJ, over the last couple of days, and I think even easily for the last couple of years, when decisions of the court, the Supreme Court, have been made, that what is taken into consideration is jurisprudence. It is the rule of law that is taken into consideration over and above everything else. It is interesting because in conversations with some of the members of the Supreme Court, and I believe one in particular said that, also what is taken into consideration is the prevailing circumstances in country at the time. And how would you say that the Supreme Court has dealt over the past few years? What has been taken into consideration with a number of the rulings that have been made, decisions that have been taken? Is it the rule of law? Or is it the atmosphere in the country, or is there a balance between the two?
The most fundamental consideration and the most central is the rule of law. Because the rule of law is the foundation of everything. Is the foundation of the peace, the tranquility, basically the business. It is the rule of law that is known by everybody. And that is the one that is written, and that is the one that governs the country. So every decision of the Supreme Court is predicated on the rule of law, principally the Constitution. Mm-hmm. What does the Constitution direct and dictate? Then we go to statutory laws. What does the particular statutory law provide? Then within that context, there is also the social context of what is happening. That may have an influence here and there, but majorly is the rule of law, is the interpretation and application of the Constitution, which we cannot remove and which cannot be overtaken by the social context. Whatever is happening in the social context must be premised, must be predicated on the rule of law, because the rule of law is the one that cuts across everybody. Yeah.
What's the process of decision-making in the Supreme Court? You're 7 judges, right? So a matter is brought before you, all arguments are brought before you, and then you say, now the court shall retreat to render its decision. What happens at that point? How do you go about that?
Every individual judge has to read the file. If we are sitting 7 of us, the quorum of the court is 5. In the random dairy matters, we deal with 5, a bench of 5. But matters that are bearing significantly to the larger public, general public, the matters affecting the nation, we all sit 7 of us. And it's very, very difficult because, that is a very small bench. Doesn't allow a lot of latitude. We wish we were 11, where we could have 2 benches sitting and the CJ being a little released to deal with the Judicial Service Commission and other obligations. I have almost 67 statutory duties to perform under our laws. So it's a very busy office, and being the head of the institution, the administrative end of the institution, you also deal with so many administrative issues. But there we are, 7 of us. So each one of us read the file. We also research on the issues that have been raised in the file before the hearing, because we have a team of law clerks who assist us with the research. So they prepare what we call bench memos for each of the justices that summarizes the case, that puts together the issues. But we read ourselves, and then we have a conference before the hearing of the matter.
Madam CJ. So each judge will have their own set of researchers who will give them their memo.
Yes.
And the memo from researcher A to Judge A may not necessarily be the same, the memo that goes to Judge B.
It may not, because these are different people.
Okay.
Perceiving the matter differently. They are lawyers also. Some of them are quite senior, over 10 years experience.
Okay.
So before we go to the hearing, we conference. Then we go to the hearing, we hear the matter. Like now, we have been doing it virtually. And the Supreme Court is by way of submissions where counsel or the parties will highlight the issues. So after the hearing, we retreat again for another conference. And sometimes we may conference for days. So it's through the conferencing that we look at the various scenarios, various understandings, various research. We look at the law, and then we agree. Are we agreeing on issue number 1? And all of us will say whether we agree. Issue number 2, issue number 3. If we agree on all of them, then we can have one judgment. But there are times when some of us will say, I agree, but my reasoning is different.
Right.
But the outcome is the same. That's what we call concurrence. Then we'll have a dissent, somebody who feels that they have a divergent of opinion, and then they can write a dissent. Perhaps not on all the issues, but on the particular issue they dissent on. We were asked, how come we are having unanimous decisions? We tried to write separate judgments during the BBI, and the judgment of the Supreme Court, you can check it, is over 1,000 pages. It's very difficult to read because, 150 pages, 200 pages for each judge. So therefore, if we are unanimous, then, and it's very difficult also because each one of us has to read those 7 opinions. And it takes a lot of time. It can take a year, by the time you read the 7 of them, by the time you see now, like when you're making the final orders, who is agreeing and who is disagreeing, who is dissenting and who is concurring. So the BBI decision taught us a lesson that, unless it's absolutely necessary, if we have agreed on the issues, then we can have one composite judgment. It is easier to follow as a president. It's easier also for the students who follow our judgments. It's easier for the citizenry. It's easier to summarize it and give a media summary.
So in this conferencing, when you do it, how is it? Is it a debate? Do you debate? Or does a judge come and say, this is my thinking about this particular issue, number 1. This is why I think I disagree. And then all of you say, we respect your opinion. Okay. Judge number 2, what do you think, Honorable Justice, or so and so? Is that how you do it?
It's the way we do it. It's like you have been to our conference. We do it in a very orderly, systematic manner.
There's no debate. There's nothing
we
like
begin.
Judge A,
what do you feel? What is your view on this matter? So Judge Hay will explain. I've listened, I have read, I have reflected, and this is what I think. Then go on and say their position. Therefore, I come to the conclusion that this appeal should be dismissed for the reasons that I have given, or this appeal should be around. Then you go to Judge B all the way until now the Chief Justice. I'm always the last to speak. Then, of course, from the conversation, you know whether the appeal is being around or dismissed. I also have my view. Is it going to be around or is it going to be dismissed? And I say my view.
So what's the point of conferencing then?
That's conferencing.
So there's no point for one judge to try and convince the others?
They do.
Is there a point where
they
judge,
do
judge
because
five,
out of those issues,
right,
they will say, for me, I think this appeal is for dismissal. Whereas the other 4 or 5 are thinking this appeal is for allowing. So then that is the point of very serious debate.
I see.
Yes.
I see.
Yes.
The reason I'm asking
And
this,
we may not even end up there. We may adjourn to go and do further research, say do more research on this area. So we need another focused discussion on the area of discussion. We come back for another discussion. Like for BBI, we conference for 2 weeks.
I see. The reason I'm asking that is because, of course, what's in the public domain is how do they arrive at the decisions that they arrive at, right? And are they protecting the Constitution or are they protecting other interests? Or is there influence that comes to the judges in between the entire process of hearing a matter up to the point of making a decision? Is there room for external influence into the decision of even as an individual judge? Is there room for such?
You know, Latiff, you can only ask me whether there has been external influence over me. What happens to other people, you may not know. Would I know what's happening to you, Latiff, in your house, in your private spaces?
Well,
I wouldn't know. But as president,
Yeah,
we expect you to know.
because I have 7 times 2 eyes to
Yes.
see.
We don't care how many you get.
Yeah,
The
it's,
public-
it's very, very difficult.
The public expectation
It's
is that
no,
President of
let
the
me
Supreme
speak for
Court-
myself. Nobody has ever tried to influence me as a trial judge, as a judge of the appeal, as a Supreme Court judge, and as the president of the Supreme Court, because I cannot allow, the Constitution does not allow us to be influenced by anybody or any authority. So whoever would be attempting to influence me, I would quickly refer them to the Constitution because it's written there in black and white.
would you make it public?
But I'm making it public.
If somebody did try to,
I would.
Okay.
I would. And what I would do, like during trial, when I was a trial judge, because you'll be approached through maybe the church, through your merry-go-round women group, and they don't do it directly. What I did was to declare immediately that this is not a position where you can be approached. And if you did approach me, the thing I'll do is expose you, and I will also recuse myself from hearing the matter. So nobody approached me. And I told all my associates, my relatives, my friends, that if you ever speak to me about a case, that is going to be the end of our friendship. Because our friendship is not predicated on my work.
Just
my work is separate.
Being your friend is difficult. Huh?
It is. We have just to talk about friendship. Our children, we reminisce of our old days. We reminisce over the nice things we like to do together. It's not predicated on favoring them with a judgment.
If somebody has...
And
we
it
want-
cannot be favored.
Justice Martha Koome, Chief Justice and President of the Supreme Court of Kenya City. You had a question before you took the break.
Several actually, but let me ask the one which I consider to be most pertinent. What has the Supreme Court done to ensure that the public understand its mandate, its role, and how that affects and influences their lives?
Unfortunately, for judges, we do not communicate the way politicians do at funerals, at religious
Church services.
church
Weddings.
services, weddings. We communicate through our judgments. But we are trying to set up a communications department that can continuously, now that we are doing things technologically, that can continuously let Kenyans know what Supreme Court does. And I thank Spice FM, Standard Media, and the KTN, because you have been giving us some airtime. Justice Thursday, which comes, I think, after every 2 weeks. Every week, actually, to explain to Kenyans what it is that the judiciary does. How can you access justice in every court, including the Supreme Court? What can you file before the Supreme Court? So we need more engagement with the public, because we are doing a lot for the public. We have what we call the multi-door approach to justice now. You don't have to come to court to resolve your dispute. We have the court annex mediation, whereby you can discuss your matter, enter into an agreement, and we adopt that agreement as the owner of the court. We have the alternative justice system that has incorporated our customary way of resolving disputes. You will recognize that Africa is the depository of knowledge on dispute resolution. Every community and a way of resolving their own disputes, which we discarded for the colonial formal justice system. And our justice needs survey has revealed that it's only a very small percentage of Kenyans who can access the formal justice system in the courts. So we resolve our matters in our communities, before the chief, before our religious groups, in the marketplaces, before our nyumba kumi. And therefore, we must connect as a judiciary with those forums where decisions are being resolved every day and adopt a way of working together with those groups. And that's what we are doing under our program of alternative justice system.
Why I asked the question?
Dispute resolution is very, very important.
Absolutely.
And if this country embraced dispute resolution as a first resort, we would never have gone through all this that we have gone through politically. Because if you look back, you will see that people started with a political dispute, which ended up in the court. The courts have no legal solutions for political disputes, because what we do, we try to make them legal. These political contestations, we try to look for the issues, to look at them through the Constitution or through the Electoral Act. At the apex, people are divided down the line. So whichever decision you make, you will have an equal number that is dissatisfied with that decision. So they end up at the table to negotiate, NDR. Then they come up with a solution. Nusu mkate, handshake, broad-based. If we started there, would we have suffered the kind of bloodshed, the kind of destabilization, property loss, the kind of trauma the country has gone through? So it is important for us Kenyans, first of all, to know we are Africans. We are under a system of resolving disputes, which is restorative, which creates harmony, which leads to a handshake, and people thereafter live in harmony. So this is where we are trying to connect with the public, to understand that the judiciary is a facilitator and a connector. So when we tell you embrace NDR, it's not because we are unable to resolve the problem. It's because we know the courts determine. We don't resolve.
It's a determination.
Yeah, because from there somebody is aggrieved. Then if you have members of the same family, it's a succession matter. You are coming from the same household. You will be divided. Your children will be divided for generations to come. But if you agreed among yourselves and you greeted each other and you brought that agreement and we adopted it as the court, then we become a facilitator, we become a connector. We build harmony. we build unity, we build peace. That's what we are looking for, to connect with Kenyans.
You actually have connected, because of the three arms of government, the judiciary in this country is the most trusted of the three arms of government. And as you correctly put it, it is through the judgments, yes. But I look at the transformative nature of what it is that the judiciary has done to try and ensure that Kenyans find ways of resolving the myriad of issues that they have. We have a front row seat here, so we know. It's talked about every Thursday, but there are very many people who don't know, and because they don't know, they can't benefit from something which actually exists. I personally have participated in some court issues that were online, and I was actually fascinated. Now, these are things that didn't
exist
before. They simply didn't. So everything about it is as useful as it is known. The more people know it, the more they will consume it, and the more they will benefit from it. And the opposite is, of course, true. Now, my last question to you is, if somebody has a complaint against a judge who is in the Supreme Court, where does one take it?
Oh, many places. First of all, if you are aggrieved by the conduct of a judge or a magistrate, we have inbuilt systems and structures of complaints. Judicial Service Commission exists to deal with those complaints. You can file a petition before the Judicial Service Commission if the grievance you have is the one that leads to a removal of a judge. Within the judiciary, we have established a system of dealing with complaints. We call it the Office of the Judiciary Ombudsperson. That office, and it's online, something that we really need to communicate with Kenyans, that the judiciary has gone ahead of the entire government to operate virtually, to have e-filing. So you do not have to walk to the Supreme Court to register your complaint. You can do it online. And we have explained to Kenyans how you can launch your complaint. So it could be a complaint of the judge owes you money. I think that's a civil case. You can also be advised to file a suit, or the judge was disrespectful to you. Is that a matter of misconduct? So that, or whatever complaint it is, it will be handled until resolution. Because of the fair administrative action, the rule of law requires fairness. We cannot mob lynch anybody. If there is a complaint, we must give a chance to the other side to respond. So that is why people think that if they filed a petition against a judge before Judicial Service Commission, they are not seeing results in the next 1 or 2 months, because the complaint will be processed. We will do our own investigations. We will conduct a hearing, and the judge will be given a fair chance to defend themselves, including with a lawyer. Then a decision of the panel will be taken before the whole Judicial Service Commission. We're talking about human rights. We are talking about somebody's livelihood. Then the results will be taken, if they are for setting up a tribunal, to the president to set up a tribunal. Since I've been the Chief Justice, I've seen those processes. I think I'm seeing the 4th one now. Yes.
Chief Justice, I want to look at the interplay between the three arms of government. One does not sit in a position of authority over the other. It is assumed that all three sit independently, but in the same capacity as forming government: the executive, the judiciary, and the legislature. Most recently, we have heard from one arm of government today. I believe it was actually at the conference, at the celebration of 12 years of the Supreme Court, where terms such as judicial interference come up. where terms like, warnings to the judiciary about what they can, cannot, or should not do. Where do you sit? Where is your position there when you hear things like judicial interference that should that in one way or another come against, and I put that in quotes, against the processes that a country would take?
Yes, like you rightly say, Amimo, each of those institutions are independent, and that independence is created by the Constitution. It's none of our creations, and there is every justification for that independence and separation of power. So when the executive or the legislature complains about judicial overreach, we also complain about their overreach. And we defend the independence of the judiciary most vigorously because judges, magistrates, decision makers, adjudicators, we are supposed to decide the cases independently the way we see the evidence and the way we see the law. And if they are aggrieved, there are mechanisms of appeal. If you are aggrieved by a decision of the magistrate, please do not verify them at the church, at the funerals, at open places, because we have no way of responding. Appeal to the High Court, and the High Court will correct that mistake. And if the High Court does not correct that mistake, the Court of Appeal will. And if it's a matter that can come to the Supreme Court, all of us cannot make the same mistake.
Chief Justice, do you really think they make those complaints with a desire to have such decisions re-looked at, or do they not sound like warning signals that come out to the public in terms of what the judiciary ought to or ought not to do?
I think to be a judge or an adjudicator, a judicial officer, you need a very thick skin because you should not be listening to what the public is saying, because you will hear many messages depending on the way they want the case to go. It will be either the executive, it will be either the legislature, but it will also be the public, the way they would want the case to go. So you must always remain very faithful to the oath of office that requires you to be independent, to be impartial, and to decide a matter without any bias or without any prejudice. In fact, that is the oath of office that reverberates and rings the bell to you all the time, so that so long as you're doing the right thing, you're just interpreting the law and the evidence before you, you're making a determination, then you are a functus officio when that matter comes again, because you decided, let them go on appeal. And the people trying to prosecute their matters in public, they know it is wrong. They know that they are circuiting the system. They are bringing to bear undue pressure on the adjudicators who have a matter live before them. So that is why you heard me say sometimes I don't listen to the news, because you know you don't want to be biased. You want to just remain with your own mind.
Truthful to the law, and truthful to, what has been laid out in law. When, again, I go back into the spirit of the Constitution and the spirit of our law. In the spirit of the Constitution, it came out into the letter of the law. And people have talked about our Constitution as being an activist Constitution. Just starting from the very top and says it establishes the sovereignty of the people. And then it comes and looks at how the people then exercise that power. They have the power. They establish these institutions and they say the judiciary shall be the one that makes sure that this Constitution lives and continues to breathe. It has established the Bill of Rights, a very progressive one. Article 10 of the Constitution on how we expect that state officers shall behave and how we expect that our relationship with the public shall be. At Chapter 6 of the Constitution, and so on and so forth. And even in areas where decisions that are made shall come from concurrence with the sovereign, and that's the people. So the expectation is that the Supreme Court, that's given that mandate of defending the Constitution, will always be considering, even as you're setting the jurisprudence, it'll be in the defense of the Constitution, primarily. Am I right? Now then, the public perception at present, for example, if you just look at some of the public sentiment, is there's a feeling that the judiciary, the Supreme Court is dropping that ball. That the Supreme Court is looking at matters in terms of what has been presented before it, but forgetting that there is the spirit of the Constitution of Kenya.
The Supreme Court, Eric, has not dropped the ball. The Supreme Court has breathed life and spirit to the Constitution, and we continue to nurture our Constitution and to celebrate it and to uphold it. For instance, the recent case from the Supreme Court on the Finance Act. Unfortunately, many people have not read that decision. They have not even read the media summary. When I saw the debate that was taking place, immediately we rendered that decision. First of all, the discussion was the Supreme Court has disagreed with the Court of Appeal and the High Court. That is wrong. We did not disagree with the High Court. We were in tandem with the High Court. The only dichotomy was with the Court of Appeal when they declared the entire Finance Act unconstitutional, from the title to the descriptions, to everything, to the schedule, to everything. We hand up, and for the reason that there was no public participation after the second reading of the bill. You remember, Eric, that the Court of Appeal and already established the parameters of public participation in a case which we call Pivans. The Supreme Court and also determined the parameters of public participation, mainly in the BAT case and also the BBI case. Now, when you come the second round and say after that public participation, which was found to be satisfactory, because even the Court of Appeal agreed the first round of public participation was satisfactory, then you move the goalposts and say after the second reading, you must go back to the public. The Finance Act or bill has timelines. It must be completed within 60 days. And we analyze that process, the judgments, and so actually the amendments which were introduced, the 17 or 18 of them, were issues that arose from public participation. And we were able to say, this is what this group said, this is what is contained in this clause. This clause is from this body, this clause is views from this body. So we said that this is the views that came from the people and were incorporated
into the third reading.
In the second reading. In the second reading. Therefore, it was not satisfactory for the Court of Appeal to say they needed to go back to the public participation when the views that were actually added were the views that came from the public participation. However, the Supreme Court went on to emphasize that if there are new issues that are being introduced in the second reading that did not emanate from public participation, then it is necessary for Parliament to formulate a framework of engaging the public even after the second reading. Even if there is a short window, they must have a way of telling the public that these are the new issues that have arisen from the floor, not from public participation, but, from other sources. So we have breathed life and spirit to the Constitution.
Were you satisfied that Parliament did that? In the case of Finance Act 2023.
Satisfied?
That there was nothing that was introduced after the second reading that had not been canvassed during public participation.
We did that, and I invite you, Eric, to read our judgment. Actually, of all the judgments we have rendered in the Supreme Court, this is the judgment that I find very, very sound.
What then would you say to those who feel that you lowered the bar on public participation?
We
on the
didn't lower.
expectation of
We
public
even
participation?
told Parliament and gave guidelines, very detailed guidelines on what constitutes meaningful public participation, and directed them for the 10th time to enact a law that guides the country on public participation, because even them, they don't want to be experiencing this shock all the time. They need a framework. They need to be guided. They need, to settle this issue of public participation. It's almost 14 years, and it's really been a bothersome topic. But we did not lower the bar. We actually increased the bar by saying if you introduce something new, it must go for public participation. And we evaluated what was there, and so it is issues. The 18 issues were raised by the various parties who made submissions, either by written memorandums or by appearing before the committee.
Your Ladyship, you must also address this one. This is at the point of delivering the decision of the Supreme Court on the presidential election petition in 2022. There are those that felt that the court came out with language that was not what is expected of the Supreme Court. Words like hot air, wild goose chase are still painful to many people.
Well, if somebody feels hurt because of the language that you have used, it's always an act of humility to apologize and say we would apologize to those who felt hurt. But if you read each of the paragraph, it would explain why that was the conclusion. Because if there were allegations that were not supported at all by any evidence, then the conclusion is that which, if it is hurtful, we apologize. But, that is the conclusion we came to after evaluating what was brought to us in a very, very big way. But it turns out that it wasn't what was being arranged.
What should a court like this do? A final question, and we've been given time for the news. Let's just asking the final. What would the court? What do you like to see when parties come to court with such kind of matters? For example, they allege, but they do not have substantive evidence, and yet they've taken the court's time, the country's time. Instead of using the word hot air, it's okay. We've taken the apology. But what then would you like to see from parties that do such kind of things?
That's why we have opened what we call the multi-door approach to court. And I think the Bible is very instructive. Before you take your brother to court, reason together. So look at this case which you are bringing to court and see whether it has a leg to stand on or even a hand to hold on to. If it doesn't have, approach your brother and negotiate, mediate, and look for another alternative. Don't come to court because you'll end up more hurt. You end up with a decision that maybe makes you even pay costs. Yes.
Madam Chief Justice, thank you very much for joining us today.
Thank you for having me.
We look forward to the next one.
Thank you.
Asante sana, and say hello to all our friends, judges.
And
of the Supreme
thank you
Court
so
of
much
Kenya.
for the support you have always given the judiciary to inform the public what the judiciary does for Kenyans.
Thank you. The Honorable Chief Justice Martha Koome, Chief Justice of the Republic and President of the Supreme Court, has been our guest.
This is the Situation Room, the only way to start your day.